Hi, I'm Debbie Moraes. Welcome to Legal Matters. This is the program that's been designed to address the critical issues that are facing consumers and businesses today. Legal information, practical solutions, and straight talk about a wide variety of topics that affect your work and your home life. There's nothing like the inspiration that comes from desperation. In this economy, if you can't find a job, make one. Or maybe you do have a job, but you're interested in pursuing the American dream, being on your own and being an entrepreneur. In the past couple of years, American startups are at an all-time high. So today we thought we would discuss the legal issues and, most importantly, some of the potential pitfalls of starting a business, and if we have enough time, hopefully, those that are associated with buying a franchise. So, as we usually say, let's get started. And once again, we'd like to welcome our lawyers from Audette Bizarre Cordero Grasso Law Firm in East Providence, Jackie Grasso and David Bizarre.
Hello.
So, let's start with the basics of you're an entrepreneur, you want to be an entrepreneur, you need to start a business and define its legal structure. There are a couple of options. What should we do? What should we think about?
First thing you want to do is see an attorney as to what entity you want to form.
There's both an attorney and an accountant, because there's both the legal issue and the tax issue. So what often happens is someone will come to me and say, I want to create a new business. Do I want to be an LLC, a partnership, a subchapter S corporation, a C corporation? And they go through all that litany of things. And I say, well, why don't you go speak to your accountant? And then they go speak to their accountant, and their accountant says, well, you really should speak to the lawyer first. So it's the chicken and the egg to some degree, but all of those entities give you some legal protection, except for a sole proprietorship. So the real issue is, how do you want to be treated for tax purposes, and on the investment end, are you looking to just be a sole proprietor owner, or will there be other investors? That might affect the structure you choose as well.
So we need to know what type of business it is as
Yeah,
well.
and what the goal is.
The goal is. Yeah.
I think obviously people have heard of sole proprietorships and maybe partnerships and the corporations. If you are a person who just wants to do a home-based business, could you say definitively that having a sole proprietorship works? Or do you really, even with a home-based business, have to think about incorporating because of the liability of some sort?
Everybody's inclination today is to incorporate because they feel as though there's limited liability when you incorporate, so you don't have to worry about being sued. However, when I always tell people about limited liability, I always tell them it's just that, it's limited, because there are laws that allow you to pierce the corporate veil, so to speak,
Right.
and that's for certain misconduct of the officers. But your question asks is, what if you want to be a home-based business? Again, I guess it depends on the type of work you're doing. If you're in a medical field or, doing some type of assistance with people, I would say you will probably want to be incorporated. If you're transcribing notes, or, you could be a sole proprietor. Also depends on how much control you want. With a sole proprietorship, you have you can pretty much do anything, operate your own checkbook, not have to worry about tax laws when it comes to corporations, because you're limited in what you can do with your finances in a corporation versus a sole proprietorship.
There are certainly some benefits to being incorporated, either through an LLC or some of the other structures that you might use, the corporation subchapter C or S. But there's also tax implications. Depending on what kind of business, as Jackie said, you're going to be running and how big it's going to be and how much money you might want to put away for a retirement account even can be impacted on what type of things you might do. Your health insurance benefits might be impacted. So there's a number of things that can go into the determination as to whether to incorporate or have an LLC or just maintain a sole proprietorship.
For many who had a job and then their job was suddenly defunded for whatever reason, many will say, well, I did thus and such a work, so now I'll become a consultant doing that kind of work, and I can do it out of my home. So if you are a consultant, do you necessarily think that that is worthy of or needing to be incorporated? Or could you do that flying by the seat of your pants as a sole proprietorship for a while?
Again, I guess it would depend on what you're consulting about.
Business, say, for example.
I say, it goes back to what the person's goal is. Maybe you could do you could have a sole proprietorship. I think our general advice to people is it's always better to incorporate.
Yeah, we like to limit liability. On the one hand,
expensive though.
On the other hand, Jackie and I will always tell our clients, no matter what you're doing, make sure consult with that third professional, the insurance salesman, and have liability insurance. It's usually very inexpensive depending on what you're doing.
When someone wants to start a business, I think mostly, if it isn't about the incorporation, they may think that they could start on their own. And there certainly are websites that will, SBA.gov and SBDCs, certainly can give you some basic information about what registration fees or permits or whatever that you have. Do people need to have a lawyer check further into other either registrations or licenses that they need, or is that something that a person can DIY, do it yourself?
Well, the Secretary of State has a quite an expansive website, so they can direct you to what you need. And again, it depends on what you're doing. If you're taking a name that's being used from someone else, in the past, the lawyers would do a name search. Now, because of the internet, you can just go on the Secretary of State's website to see if that name has been used. And if it hasn't been used, they can reserve it for a period of time. So it's really easy.
It is. And most people have the ability to use a computer and do that. But the purpose of consulting with an attorney is not just to have the attorney fill out paperwork that you could fill out, but to get advice and discuss with the attorney what are the advantages and disadvantages of some of these different entities. Again, like I said, there's some tax implications, but there are legal implications. If I'm creating a business that is going to, at some point, I hope, really expand, and I'm going to want to sell stock to investors and have that kind of ability, I might want to form a different type of entity or corporation than if it's always going to be me or me and my wife or 2 or 3 other people, and it's never expanding. So what are the different implications of those types of things? That's what you want to speak to an attorney about.
When someone starts a business or even talks about it, they don't generally think about, it may come to a conclusion by my choice or not by my choice. If someone says, I have a good friend, they were going to become my partner, sounds like a good idea, but certainly it's fraught with many issues. Care to explore those?
No, definitely want to speak to an attorney about that. If you're going to have a partner, you want to make sure you have something in writing, partnership agreement, or form an LLC or an LLP.
Or a shareholders agreement if it's a corporation.
Because you need to determine how your corporate profits and losses are going to be divided. And if there's nothing in writing, the Uniform Partnership Act says it's 50-50.
Right. And you may not want to share profits equally. You may not want to share losses equally. And then there are all the things that lawyers are supposed to be trained to think of that you don't want to think of, such as, all right, there are 2 of us. We add a 3rd person. What happens with all of the stock? Who's giving up stock? Who's keeping stock if it's a corporation? What if one of the partners leaves to go compete with somebody, with us, with somebody else? What does the provisions in our agreement provide for taking his stock back and limiting him from doing that? What if he's leaving to do something else or she's leaving to do something else? What if they die? These are all different things that can happen during the course of operating a business that you need to plan for.
And how about who makes a decision if we are such good friends, we want this to be 50-50? How do you make a decision with a 50-50, one says yes, one says no? What happens with that?
It's like the Mexican standoff, because if they can't decide, then you see the beginning of the end of the business.
And often that is something that will doom a business if there's not a mechanism to making those decisions. Sometimes what we would do is, who's running what? What's your expertise? What's your area? Do you want to try to agree on everything? Absolutely. It's the best way to do business. But if there are things that you're not going to be able to agree on, but you already have a mechanism for deciding, if it's, for example, we're selling widgets and one person's in charge of ordering the widgets and the other one's in charge of shipping the widgets, well, there's a decision in one area or the other, you give that partner perhaps final decision making on that area that they have the expertise in.
So from what I'm hearing you say, apart from the things that someone might know to ask you, these are the questions that you would include in your consulting or your work relationship with them. And
we also want to know how much the investment, what the amount of the investment is of each partner. Certainly if one's putting in 80% of the investment and the other is 20, you don't want a 50-50 partnership agreement.
Unless perhaps the 20% person is the one who's actually going to be running it.
That's true.
And now there are other ways of dividing up the investment and the return and the salary that the person's earning for putting their effort into it. Because remember, a corporation, if it's a corporation, is a separate entity. And so the way it's structured is shareholders own the business. So what do the shareholders want the people running the business to do? Maximize profits so that there's a return on it. The people running the business want to get paid for doing a good job. So you can have employment agreements, that could be an issue. You could have, again, shareholder agreements, and all these other things that come into play that you really need to speak to an attorney about setting up.
If the two would-be partners come together as one having money, the other one having knowledge or expertise in the field, would you be the ones to, I don't want to say mediate, but help determine how to weight those things appropriately so that each gets fair dibs on
Sure.
how to deal with the business?
That's part of what we would do as
Yeah.
attorneys, is to sit with them and make sure their goals and expectations are turned into words on a piece of paper.
And by the way, too, if there's a partnership, we don't necessarily represent both partners. It may be advisable for the other partner to get independent representation.
Yeah, and in fact, again, remember I said that the corporation is a separate entity. We may represent the corporation. Each shareholder or partner, if it's a partnership, may have their own lawyers. So it depends, what's being discussed, what's at issue. And again, we're not mediators in this usually, so sometimes people do need to get their own representation.
So while we're talking about you as lawyers, you two work together in the same law firm. Might one be representing one and one representing the other, or how might that not play out?
Not a good idea.
Doesn't work.
No, that's a conflict of interest. It's
Right.
not advisable under rules of professional conduct.
Right.
Good to flesh out. And
Yeah.
good
Yeah.
to have you have an opportunity to say that. Whether you're starting a business as a corporation or even as a sole proprietorship, and you have to find a place to live other than your home. I have heard and have experienced as a business consultant myself for small businesses, those who get involved with leasing proposition those have their own problems. Can you help to the person who's involved in fleshing out what the terms of a commercial lease are about? How do we avoid some of those pitfalls? What are the things that you advise someone to look out for?
Well, we want to look at the lease,
Right.
make sure it's in writing first and foremost. Usually there's another attorney that's involved.
Right, that's drafting it for
Yeah.
the landlord, perhaps.
Oh, we can, yeah.
You, at some point, thought we might want to talk about franchises,
Shortly.
too. So this will apply as much to that situation as to someone starting their own business, perhaps a restaurant, and going out and opening up their restaurant on Main Street, and they need the restaurant storefront to open it in. There are three things, I think, that are critical in a lease for that type of situation. Number one, you want to know what you're paying for rent. And is it a triple net lease or is it not? Meaning, are you paying for all the expenses or just a rental each month? Number two, it's the length of the lease. And that has a two-edged sword to it. One side of that sword is the longer, the more time you have to establish and get a return on your investment. This downside is if you don't succeed, you're on the hook until they re-rent it to someone else, potentially, as a contract. The third thing I like to do in those things is to shorten the length of the initial term, but have option periods, so that the lease can be renewed at your option.
Yes, I guess the experiences that most cry about later, and the thought is an ounce of prevention worth more than the pound of cure, the termination portion of it. When you enter into a lease, whether you're a franchisor, a franchisee, or a sole proprietor, presumably you're going into the business and you're planning on succeeding, but most don't think about that termination option. And how do you advise someone to build that in? Obviously, you don't want to say to them, we're assuming that you could fail inside of a year and a half or two. We don't want you to be on the hook for the next 10 years. So is that when your options make a difference to shorten the term of that lease?
They can. Now, just
What
to
else?
overlay the franchise on top of the lease, what I always have to make sure of, and what anyone doing this should make sure of, is that, for instance, let's say it's a Dunkin' Donuts or a Honeydew Donuts or something of that nature. You want to make sure that your franchise, which is a contract and has an agreement with a length of time to it, matches up with the lease. So you don't want a franchise agreement that goes shorter than the lease, and now you're stuck leasing a piece of property without that name anymore if the franchise is terminated. And oftentimes, to make sure that that doesn't work that way, the actual franchisor will be the one who enters into the original lease, and then they sublease it to you. But if that's not the case in this particular instance, you have to make sure they match up.
The other thing, too, we advise people about is the personal liability, because I've rarely seen a lease where the lessor didn't require a personal guarantee.
Right.
So even though you are a corporation and you have limited liability, by signing a personal guarantee, you're saying to the landlord, if my corporation goes out of business, you can sue me personally.
Yeah, it's
Any way to protect someone from
Yeah,
that?
there's an excellent way. Don't sign a
Don't sign
personal
it. Yeah,
guarantee.
that's right.
And you have that as an option
It's
at the
that can be
outset.
negotiated. So depending on what's going into this particular piece of property, in your track record, you may or may not be able to get the landlord to negotiate that. One thing you might be able to do is get them to agree that there's a limited time frame on the guarantee if you're new, so that I don't have the track record behind me, but I'll personally guarantee it for the first year. After that, we're up and running, that goes away.
So again, back to the ounce of prevention, if you were working with someone before they negotiate a lease, would you be likely to negotiate for them or just suggest to them, here are the things that you might want to speak to that
We like to be
landowner?
actively involved.
Yeah, we usually there's an attorney for the landlord and us, and we are going back and forth with them, and they're always insisting, nope, we need the personal guarantee. And we're saying, nope, this isn't going to happen. And the leverage will be whether or not the landlord's been sitting with an empty piece of property for a long time and how great a location it is for our client. So that's always subject to negotiation. That usually can be an arm's length transaction as long as one side or the other doesn't have more of that leverage.
Okay, and on the topic of money, because everyone who's starting a business wants to pinch their pennies, and in that vein, if someone thought that they could start a business on their own, but they have to deal with a commercial lease, is this perhaps a thing that you or any other lawyer might do as an a la carte service, just to make sure that they don't get burned on that particular hook?
Sure.
For that particular
Interesting.
situation.
Yeah.
Yeah, I mean, we can do things hourly. That's something that you
A la
can come
carte?
in and say, yeah, we want to hire you to help us through this. We don't need you to do every single piece of it, but whatever you do, we'll pay you hourly. That happens. And to go back, when you were talking about saving money for the person who's starting up, some things in leases that we have negotiated in the past are an abeyance of paying any rent at the beginning when you're doing the build-out to turn the property into the area that will be successful for you. In other words, if it's a restaurant, you have to put in, chairs, tables, floor, ceiling, restaurant, kitchen, those types of things. Oftentimes, if this has been sitting for a while and the landlord wants to get you in there, they'll say, all right, I'll give you 2 or 3 months, no rent. You maybe pay expenses if it's a triple net lease, but you have that time to get your restaurant up and running before you pay me.
Good to know.
And sometimes the landlord actually provides money for build-out.
Yeah,
And so they build that into the lease. That's something you can negotiate. They'll build that into your monthly rent.
Right.
To pay it back.
Oftentimes.
Yeah.
I guess it makes sense to say that you can negotiate better before you sign that lease.
Oh,
have
yes.
less leverage or no leverage
You have
once
no
you do.
leverage once it's
The
done.
only way to change the lease after it's signed is you have to have everybody agree to a modification,
Right.
make sure there's a modification clause in the lease, and it has to be in writing and executed by all
A
parties.
couple of other
Good to
things
know.
about
Yeah.
the lease. That,
In writing.
I sort of broke some things out of my top 3, so this could be number 3 if I hadn't done that. The options could have gone in the term. Jackie's personal guarantee is very important, but also one of the things, depending on what you intend to do with this piece of property down the road, is the ability to assign the lease or sublease it to someone else. So, for instance, if you're in a business of doing startups, whether it's restaurants or something else, and you like to get them up and running, and then once they're making some good money, you want to sell out at a profit and move on to your next project, you want to be able to assign that lease to a new buyer. So that's something else you have to be very careful about negotiating.
Good to know. Good to know. So, if someone wants to start a business, they're a little concerned about all of the elements that go into it, they might consider a franchise, and apparently that there are over 75 industries that are very busy right now with burgeoning franchises. Of course, it makes sense. You have a built-in business system. You already have a brand that helps you launch. It has a program in place, and theoretically, that ramp time is worth some money. It also can be fraught with problems. What are some of the biggest problems that you see when someone is reviewing a franchise agreement?
Oh, when I hear franchise, I always think of the term I learned in law school, Contracts 101, adhesion contracts, which means it's always a one-sided contract. It always benefits one party over the other.
And that would be the franchisor?
That's correct. So we really need to go through the contract, and we have to make sure that it's attractive, so to speak,
Right.
or you know, beneficial to our client.
Jackie's 100% right. They are adhesion contracts because you have almost no ability to negotiate any of the terms
That's
of
right.
the franchise agreement. And there's reasons for that beyond the fact that these franchisors can be a little intractable in what they're willing to do. They can't really give you a better deal than they give Jackie. So they have to file with the state their franchise offering and circulars and all of that. And there's very little room to negotiate some of that. There are upsides and downsides to franchises. The upside, as you mentioned, is that you're starting out with a known quantity. There's a benefit to that. There's an advertising benefit usually. There's the ability
Name
to...
recognition.
The name recognition, the ability to access their suppliers and get your materials maybe at a better rate, maybe not. That could be part of the pitfalls. Maybe the franchisor is making quite a bit of profit on what's being supplied to you, and if you had your own donut shop, I'm just using donuts and I'm not saying which one, you might be able to buy that flour or that product or that already made donut at a cheaper price than you're getting it from your franchisor. So you have to weigh and balance some of those things. You lose a little bit of control. You have to have your store match up to the specifications that they want it to match up to, which can be expensive. You have advantages and disadvantages.
Now, since you say you've studied contract law, isn't there supposed to be an assumption, too, that contracts by definition should be fair? And isn't that franchisee or that prospective franchisee entitled to some, is the word consideration, so that they have some alternatives rather than being just held hostage to whatever that single piece of paper is?
Well, that's looking at it optimistically, yeah.
Well,
Well, I would look at it this way.
this is your time.
You can either agree that it's fair and enter into it, or go in another direction. It's not supposed to be designed, and they don't intend it to be designed, that it's so onerous that you can't make any money at whatever franchise it is you want to enter into, or no one would do it. However, there are some things in these things sometimes that on the one-on-one arm's length transaction would seem to be a little overreaching. But you know that. You have to know that going in and determine whether or not that works for you or it doesn't.
I understand that Rhode Island is one of the states, I guess on the good side of the ledger, that has a Department of Administration, or DBR, that watches over franchises. So you could certainly learn a little bit and have a little bit of protection. However, I guess all franchises are supposed to have a disclosure document,
Yeah,
which
Rhode
is
Island
probably
requires that. They have to register it.
300 pages worth. Is the average consumer or average prospective business owner likely to be able to go through that and manage, negotiate it, deal with it at all, or do they really have to say, here it is, lawyer, please
Yeah.
vet it
It's
with a
very-
fine-tooth
yeah.
comb?
Yeah, and you know when it really comes up is when something's gone wrong and you're looking back to see, is there anything I can do about this? Did they do this? Did they follow that rule? Is this disclosure accurate? Are they doing what they said they were going to do? It's more after the fact, I think, sometimes than before the fact, because you could pay a lawyer to go through every single word of it. Is it going to make a difference as to whether you enter into that franchise agreement or not? I'm talking about all the disclosures and the circulars and the this and the that. It may or may not. But it always comes up after the fact, especially when there's a problem.
Yeah, so they hire us to put the toothpaste back in the tube.
Right.
You know, if you're making an investment into a franchise, it's going to be a significant investment. So to try and save money on avoiding hiring a lawyer and accountant is just, I think, a huge mistake.
Right.
I really do.
And you need both a lawyer and the accountant in these situations. You need an accountant to look at your business plan and what's being presented to you from the franchise and say, yeah, you know what, this works from a tax and profit standpoint. You need the lawyer really to explain to you what are some of the pitfalls I'm looking at. Maybe not necessarily to negotiate them for you, because like I said, some of them, very few of them, maybe there is a little wiggle room, but just to explain, you need to know that in 5 years you have to refurbish your whole store, if that's what's in there. Or in 6 years, your contract is up for renewal and you have to meet this, this, and this step in order to do it. What are all the ups and downs?
Well, if a franchise agreement or a franchise license, no, what is it? It's a license, I guess? You don't own it, you have a right to license. Is that
Right,
the
yeah,
terminology?
yes.
You may pay $50,000, $60,000, $100,000 plus all of whatever it takes to set up the business, get the lease, et cetera. And to have you vet this, is that another $50,000 or more like $1,000? And online, I will tell you, I've seen $750 as a flat fee. I don't know what, I haven't had an occasion to evaluate that, but I have seen
Flat fee by a lawyer?
by a lawyer.
Oh.
Well, .com can do anything, can it?
Well,
Who are they?
What are you going to
you don't
do,
want
scan the
.com.
document in and have a computer tell you what it is? No.
Not sure.
I would say most lawyers that do any of this kind of work would probably do it hourly, and it can be a little expensive because they have to go through every lease. Depending, if it's one location, it's one lease, but if it's more than one, every lease, all of the documents in the franchise agreement, and a whole host of other documents we haven't even talked about, because usually there's going to be some kind of SBA loan or other financing for this whole deal. So it can be a little expensive. Is it $50,000? Probably not. Is it 10? Could be.
Is it fair for a franchisor who just ended up selling to a franchisee, and it's maybe 10 years, they figure that gives someone enough time to set up the business, make a profit, and they want a renewal fee or renewal at 10 years out, that the franchisor would have the option of taking that territory over and you have no option about keeping that territory? Is that a fair thing?
I go
or
back
that's-
to the adhesion
Yeah,
contract.
well,
Is that fair?
Yeah,
Again, that
common.
may be one of the things you can negotiate, depending on if this has been an existing store, for example, you're buying perhaps that person's existing franchise agreement, but you might have the opportunity then to go back to the franchisor and say, I'll do this. However, I want you to give me that option renewal on a new agreement with you now.
The goal is you want to stay in business. You don't want to give them the ability to put you out of business.
Right, but if you did such a swell bang-up job, they might want to just take that
And that's-
territory over, and you are stuck with what after having put your
There'd
hard-earned
have to be
sweat
some
equity
kind
in
of
the...
buyout
Well,
clause in the
that's what
contract.
has to
Yeah,
be
there has
in
to be a
your
buyout.
agreement,
Yeah.
in advance.
Yeah,
You can't do
definitely.
that after the fact.
And in termination, it's one thing if they wanted to pull the franchisee's license because he didn't do it properly or he did something...
Failed to pay the fees.
Or didn't perform.
Right.
But then what about that franchisee? There isn't often enough a listing of how that franchisee can say, I'm done, I don't want to do this anymore, how do I exit? Can you help someone before that contract is signed to find an exit strategy?
Yeah, and there's a
Put that
couple
in
of
the
different
clause,
ones.
in the
Quickly.
contract,
Well,
yeah.
very
30
quickly, one of them
seconds.
is you could put your franchise up for sale and try to sell it to someone else and let them deal with the problem.
And they can't keep you from
It has to be in your agreement.
All
You
in
have to see what
agreement.
the language says.
Contract dictates.
Well, we certainly have covered an awful lot of territory here. We always say to you that if you have questions, you can feel free to contact us at Legal Matters, Full Channel TV. We thank you for tuning in, and we hope that this has given you a better perspective and helps you avoid some of the unnecessary pitfalls of joining a business. And if it's sole proprietorship or franchise, good luck. Thank you for tuning in. Legal Matters continues.